My lord and my ladies, I call the matter case number D12763 of 18 Tales SA versus KZN, DPP and others, and case number CCD 30 of 18 Zuma and another versus the state.
Mr. Court versus my lord and my ladies, I appear together with Mr. Masuga and Mr. Sakana on behalf of the applicant.
Thank you.
Lord, my ladies, I appear together with Ms. Alikari on behalf of the second accused of the applicant and so.
Thank you, sir.
Please for the court, Ms. Mayosi, Ms. Raja and I for the respondents in these matters.
Yes, thank you. Mr. Kakam.
My lord and my ladies, before I start, may I address
Paul, I understand that the aircons are not working, but I don't know how best we can deal with that. Yes, that's.
My lord and my ladies, before I start, I just want to clear the air about something in the notices. So to the extent that in the notices an impression is given, in the notice to appeal, an impression is given in certain paragraphs that the court is being questioned or attacked, and those paragraphs, I want to assure the court that that's not the intention at all. It's not
actually concerned about this.
Absolutely.
We also view them as an attack.
That's where I want to start. And those two paragraphs that give that impression, I want to apologize profusely for them. It's not intended to suggest anything untoward about the court. What I want to try and persuade the court about, though, is just the point where we fundamentally take a view that another court So on that point, I really want to say we profusely apologize for those. They were not intended to suggest anything. It was a way of suggesting where we fundamentally differ with the court. My lord and my ladies, let me start by saying then that what I seek to do today is first to not to persuade the court that it was wrong, but at least to persuade the court that on the points that we're going to raise, as we all know what the test is, we hold a view that on a number of issues that were raised by this court, there are reasonable prospects that another court will reason differently about those issues and will reach a different conclusion about those points. And of course, we say this because we, as we've stated in the notice, in those parts that are polite in the notice, that there are, in our respectful view, what we regard as errors of law that another court may believe should have been considered differently. And of course, the test that we want to place, which I think all of us can agree about, is that there's a debate about whether the test is higher now than it was. And our learned friend has given us a case, I think it's the first one in the SCA that really deals with this, the case of the MEC for health. But the test is really this. Are there reasonable prospects that the appeal court will reach a different conclusion on those issues? Now, of course, the cases keep debating whether the test is higher or lower, and I think it's a superficial discussion about this, because the test for appeal, for granting leave to appeal, can never be so high as to ask the court that gave judgment to say it was wrong. It can't be that close. And so the test is always whether the court can reasonably foresee that a higher court can, and in all probabilities will, make conclusions that are different. And so that's the context within which we want to raise the issues we raise. I think my learned friend and I will agree that the point about appealability itself, and that's the second point we're going to deal with, is that the issues that are dealt with in this case, the issues that relate to the substance of a permanent stay, we submit that they are final in nature. And any argument, any submission that those issues are interlocutory in nature and therefore not appealable is simply incorrect. And we set that out in our heads of arguments, which I do not want to repeat. But we think those aspects about which we challenge the conclusions that were reached, those areas, this judgment is appealable. And to call it interlocutory and therefore not appealable in our respective view is incorrect. But what really I want to ask the court to think about, to accept as I set out those particular areas, is truly this. First, the court commences its judgment with a concession that was made in the SCA by the then lead counsel for Mr. Zuma. And it repeats that concession in another paragraph, and I think it's paragraph 149, if I'm not wrong. And we want to deal with that because we are of the view that another court may distinguish the concession that was made from the points that we are making in this case.
But doesn't that put into context why we were here? That paragraph 1, it's a background. It's not a holding by us, but it's giving a background as to why we're here, why we were here.
Well, I hear that, but let me go to the paragraph where you quote it again. And maybe it does explain why I make the point. And if I'm mistaken, then I'll take it. But the point is made in this paragraph.
You said paragraph 149.
Yeah, I'm going to, yes. It deals with Michelle's decision. And so read together with my submission was that I think too much weight was given to that concession. And because of this, it says, after having instituted a prosecution of Mr. Zuma in December 2007, Mr. Michelle publicly announced on 6 April 2009 that he had decided to withdraw the charges against Mr. Zuma. He explained that the spy tapes had persuaded him that Mr. Zuma's prosecution was irremediably affected by Mr. McCarthy's ulterior political motives. Counsel for Mr. Zuma contended that the statement by Michelle was the clearest indication that the NPA itself had acknowledged that its conduct through Mr. McCarthy constituted an egregious violation of the Constitution, the NPA Act, and the prosecution policy. The hurdle besetting Mr. Zuma on this submission is that Mr. Zuma considered in the DA review appeal at the SCA that Mr. Michelle's decision to withdraw the charges against him was irrational and that a rational decision needed to be made. May I just hold it there? Because I'm trying to explain that, yes, I realize that if you read the quote at the beginning, I agree with your ladyship that it may well have been given the context. But when I read this, my interpretation is that the concession is given more weight than actually the legal position that it was considering, the legal issue that it was considering. And it's for that I read the two paragraphs together to say, the court is mistaken in its analysis of that concession and what it meant because of this. If you look at that paragraph in which the SCA case deals with this concession, this was a concession of law, of a legal point. When Mr. Kemp and Mr. Epstein made that concession right when after Mr. Epstein had been told that Mr. Mshe had relied on 1795D, he had no choice but to concede that point as a legal point, that a wrong section was relied on. Now that concession, in our view, is a concession not that there was no political interference. It's a concession that, yes, the decision was taken on the basis, on the invocation of the wrong provision of the Constitution.
But can I just say, come in there, Mrs. Kakane, but if you look at paragraph 80 of the judgment of the essay, it went further and dealt with the issue of ulterior purposes.
It does.
Yes.
Can I say, I've looked at that paragraph.
Yes,
What it
yes.
does, that's an interpretation. In fact, they venture outside what the concession was about. But the starting point is what the concession was. The concession was that Mr. Mshe had relied on section 1795D. That is the concession. There is no concession anywhere that was made to the effect that there had been no political interference. And of course, that court was not dealing with that specific issue. But why was that concession important? It was important because in all administrative action, review of administrative action, once you've discovered that there is an error of law, of course that case is dead because it's irrational. And once that point was made that they had relied on the wrong provision, of course it would have been foolhardy for the two counsel not to concede that point. But what I'm trying to explain is that that concession was not the concession of the weight that I respectfully submit it is given in this judgment.
But why do you say we have found that political that concession? I'm not understanding the link between what the SCA said and what we have quoted and your submission now, because if you look in paragraph 149, we then say, in our view, no case has been made before us. We don't refer to the SCA. We have quoted that, but we say before us, Mshe's decision to initially charge Mr. Zuma was in any way politically motivated. We did not depend, as I understand, that sentence. It did not depend on the...
I will take that, but I
Yes.
use the two paragraphs to interpret. So I was dealing with that concession to the extent that I thought more weight was given to it than it was for, because I thought it opened your judgment because it was important. But I realized that
Yes.
if I read it with 149,
Yeah.
Yes.
our interpretation was that it was given more weight than what it was conceding. But if I'm wrong there, then we can move, because then our case is a different one.
I think, Mr. Sekakane, it's also important, and although we refer to paragraph 80 of the SCA judgment, but if one reads the paragraph in its entirety, then I think we are just stipulating what informs our reasoning. And for that regard, we were still dealing with the ulterior motive.
Well, and I'll get to that point as well, because I was at pains last time I was here trying to distinguish our case of motive, which that our case was not about motive, but was a case of the NPA violating its act and the Constitution in the sense which is common cause, that McCarthy interfered, that Nguga and McCarthy took political considerations in making that, and that is not disputed.
No, but it's not common cause. I just want to correct that. It's not common cause.
That McCarthy on the spy tapes was taking political considerations and speaking to someone who was outside the NPA.
It's your contention.
No, it's actually common cause.
Okay.
It's not disputed. No one disputed that discussion. No one has disputed.
No, not the discussion. That it is common cause. You were saying that it is common cause that McCarthy and Nuka politically interfered. Not about the discussions between them. We know for a fact that those happened. But as I understand it, this is not common cause between you and the state, that the prosecution was politically motivated.
Well, my lady, it's a question of extent. If they definitely differ with us that there was political interference.
That's all that I want to correct.
But let me state a fact. Let me state a fact. We can debate what we think of this fact. When a prosecutor, in violation of the NPA. But I think I must say the act.
No, but all I'm saying is I understand your submission. All that I was correcting was that it is not common cause.
Well, can I finish the point
Yes.
then? Because I think it is common cause. It is common cause that a prosecutor was discussing prosecution with a person who is external to it. Now we can debate whether that discussion about Polokwane was political or not. And it's immaterial. Because in terms of the Act, of the NPA Act and the Constitution, the independence of the prosecutor is sacrosanct. And a discussion about how a person should be charged and when being taken for political considerations is common cause. It's on the facts, it's in the record that discussion included timing it in such a way that a conference that was outside the NPA's purview was being considered. My Lord, we accept that the judgment reflects your own reasoning and views on the facts that we placed before you. But what we say is that we raised the following points. And I think your paragraph 150 truly reflects the jurisprudence of the court on this issue, the philosophy of this court on this issue. And I have no qualms, and I'm not trying to persuade the court to change that philosophy, that the violations that we raised, that the prejudices that we raised, that have been caused by what we call political interference, have compromised the integrity of the prosecution. Of course, the court tells us that all of those prejudices, all of those violations that we raise are outweighed by the seriousness of the offense. We want to make the submission on that judicial philosophy reflected in that paragraph. Is that the appeal court may well hold a different judicial philosophy to that one. The appeal court may well not excuse a violation or actions that violate the Constitution, which is the supreme law of the land. And in their weighing or balancing of the offense.
I mean, despite the finding that the conduct of Mr. McCarthy did not have any bearing on the integrity of the investigation. Yes. And the prosecution.
Absolutely. Let me explain that, because I understand exactly where the court is coming from. The court is saying, well, whatever you say happened did not interfere with how McCarthy investigated. We make this submission to that, and I accept the court's philosophy on that point. All I'm saying is that the higher court may well take a view that the violation of the Constitution in the conduct of your prosecution, as a matter of course, taints the entire process. Whether or not there are aspects you do right, but the court may well take the view, the Constitutional Court or the Supreme Court of Appeal may well take a view that once unconstitutional conduct happens, which are the violations that we raised, once that happens, you've tainted the entire process of your prosecution. Once you violated the NPA Act, and once you violated your own independence and oath of office as the NPA, your entire process is tainted. And I'm saying that may be the distinction.
Even if it appeared that it had not at any stage had the influence or effect on the investigation and prosecution.
Well, absolutely, because if we go to section 39 of the Constitution, it will tell you the prism through which this court should see the matters that come through it. Is that the supremacy of the Constitution is such that in assessing conduct in one conduct of the prosecution, to single out that yes, there were constitutional violations in the manner in which you did this, but it doesn't taint this or that aspect. I accept, as I've said, that is how this court approached it. But I want to persuade my lord and my ladies that a higher court may well, and it has in many instances, may well see constitutional violations as much, much more powerful than little correct things that have been done. That it may well say that once, in fact, in State versus Makwanyana, which is the very first case in this country about constitution, where someone was facing a death penalty, those rights were raised in such a way that the court was moving us to a new era in which we should see whatever is done by the state, and the court should approach in terms of section 39, whatever is done or brought before it by the state through the prism of those rights. And that philosophy reflected in 150 that seeks to distinguish between, yes, you were tortured, your toes were chopped off, but that did not tamper with the investigation. The court may well approach it this way. Your hands are already dirty. It's the dirty hands principle.
Mr. Sikakana, I'm sorry to interrupt you, but I've been listening carefully to what you say about paragraph 150, as if that was the only paragraph that this court dealt with any of the violations of the Constitution, or dealing with any of the reasons for charging Mr. Zuma, any prejudice suffered. In fact, throughout this judgment, we've dealt with those things through the prism of the Constitution. And perhaps it is always important in this kind of litigation to convince us that a specific provision was indeed violated by specific conduct. And the court failed to take account of that. Because when I look at everything said, paragraph 116 onwards, we've dealt with the submissions made and those aspects that falls within the realm of the stay of prosecution. What I understand from you is to say, consider the prelude to the institution of the criminal charges. And perhaps that would be good if we could be directed.
Well, my lady, I don't know whether it's correct that I've not considered. What I said was that I was picking what is in paragraph 150. Yes. I didn't say I'm not going to deal with others. So I think you must be patient with me, because I'm dealing with what I think, in my view, in my submission, really summarizes the philosophy of this court on this issue. If you look at 149, paragraph 149 and 150, genuinely look at those two paragraphs. If you want to understand, if I had read those two paragraphs, I would not have to read other paragraphs, because in those two, one is able to deduce what the premise was. And I'm not suggesting that the court did not deal with specific things. Yes, we differ with the court in in the conclusions it reached, because our basic submission is this, for instance. We raised in this court that when the delay happened, that delay, most of that delay, which violates Section 35 of the Constitution, was largely attributable to the organ of state that is constitutionally responsible to have a speedy trial.
Just before we get to the delay, on 150, Mr. Sekakane, can you give us a credit, though, that the seriousness of the offense is one of the factors that we have to take into account when dealing with the application? How we find that versus the prejudices which Mr. Zuma is alleged to have suffered, but it is a factor. I can't remember whether it's Sanderson or
Sanderson
that is,
and
it's one of the factors that we have to take into account
Yes.
when we deal with the. At least we're not relying on the pre-constitutional error, but at least that factor is a factor that is still well in the law that we need to take into account.
Well, I think any lawyer knows that. I think it's a point that
I just wanted some credit.
Absolutely, I'll give you credit for the entire judgment. Maybe my submission. You see, this is the thing about an application for leave to appeal. I have a hostile bench because I sound like I'm saying you are wrong.
No, we're not hostile.
What I'm saying to you is this. This is something that requires really intellectual rigor and honesty. Is that your findings, your conclusions, as sound as they are to yourselves, it is, and that's a fact about intellectual discussions about jurisprudence, is that you're not the only one that's right. And in actual fact, you could be very wrong. And I'm not even saying you're very wrong. I'm saying intellectually, if you look at the jurisprudence that seems to have guided some of the points you made, another court may well reason differently. And yes, of course, my lady, you're right. In all of these circumstances, the nature of the offense that you're dealing with, its harm to society, are always important. Now, the real question that I want to put to you as you make that point is this. When you have to weigh any nature of any offense, will it always be the case that courts, all of them in their hierarchy, will see constitutional violations the way you saw them when you weigh them? And I'm suggesting this. It is really possible that a higher court will well be more offended by a violation of the supreme law of the land by the NPA. And it will say, once you violated this supreme law of the land, as the court, Section 39 requires us to see things through that document first. And so I am submitting that yes, you take that, and it comes from bail applications most of the times, this consideration of the nature of the crime. And it's something to be considered all the time. It says that in Sanderson, I think it says that in Zana. But the point I am making, where the higher court may differ with you, with this court, is that it may well give more weight to the violation of the supreme law of the land first. And I'm suggesting that, I'm not saying that your philosophy is a pre-constitutional philosophy. I'm suggesting that your approach in weighing those, another court may well say, you know, once you violated the supreme law of the land, once you violated the sacrosanct doctrine of independence as a prosecutor, your hands are dirty. That entire process lacks integrity. And that is the only point I'm making on that issue. And I submit that the appeal court may well approach even that balancing exercise differently. And it may not easily excuse the constitutional violations that were identified of the NPA and say, well, the crime is very serious, the allegation, the offense is serious. It may just believe that violating the Constitution is the first and more serious offense before you look at anything else, if it's shown.
Mr. Sikakane, I think if I understand your submissions, you're ready to deal with Mr. Zuma's fair trial rights and the improper conduct of the NPA. Can I just ask you to take one step back, because I'm trying to understand your grounds of appeal. It is said to us that the court ought not to have heard the matter, and your head of argument goes further and indicate to us that in fact this was an application in terms of section 342 capital A of the Criminal Procedure Act. You perhaps indicate to us in the application before us, where in the papers was that stated?
Yes, my lady, I knew that was coming, because this is a difficult matter that was not argued before you.
Yeah.
It was
Right?
not put
It was
before us, never mind argued.
No, I'm getting there. I'm getting
Yes.
there. It was not. Let me raise the difficulty about this subject, and say that as we put it because I will read to you a transcript in which it was raised, and I accept that it's not a point that was before you, but it's a point that we had raised as an irregularity. But this is before this court was assembled.
Yes.
It was raised, and I'm raising it not because I appreciate the fact that it's not an issue that was put to you, and it's not an issue that was your decision, but it's an issue in the context of this case that we had raised before Judge Matondo.
But when it is a ground of appeal in the matter and us determining whether there are reasonable prospects, then most certainly it had to be made out in the papers, and it had to be referred to as an application, in particularly in terms of 342A. So I understand your concession that did not serve before us when the matter was heard.
It didn't. It's an issue that I think we will raise when we go to the appeal court, but I do not think it's an issue for this court.
For this court.
Yeah.
And because to persist with it would suggest that the court was wrong, but the court never had the opportunity to deal with it, and therefore it's not the fault or decision of this court that it happened. But we raise it because it's an issue in the context of this prosecution that was raised before Judge Matondo. In fact, I don't know whether it's worth reading that transcript, because it's not before you. So you don't have to deal with it, because it's not one of
that ground of appeal.
That ground is not your ground.
In any event, that ground cannot be correct, because section 110 sub 2 says you have to plead. That's at the time when the accused is pleading, and Mr. Zuma hasn't yet pleaded to the charges.
I would propose, my lady, it's not before you,
Yeah.
and I would like to argue it where it's relevant, at the right forum.
Thank you.
Now, one of the issues we raised about Mr. Zuma's fair trial right was the delay. Now, one of the examples given about the fact that Mr. Zuma was co-responsible for the delay, and it's a point that was made by the state at the time when we argued this matter, that he was part of the, let's take the case, he took the warrants, he challenged the warrants, and the next case where I think in fact the court recognizes his right to take those on, so I'm not challenging the court on that. But where I think the delay is not, in our view, is improperly attributed to him, is the matter that went to the SCA, which is the DA versus the NDPP. Well, in the SCA, it's Zuma versus the DA. It's the Piccoli decision. We submit that those two decisions, that delay in Mr. Piccoli's decision, when he makes the decision, I think on the 25th, 2nd of July 2005, he makes the decision. In fact, the court in its judgment recognizes that as he makes that decision, he later knows he had been told that more evidence would still be sought. So when he charges, and as of course he did later, that had to be postponed, he charges knowing, fully aware that he doesn't have all his ducks in a row at that point. And we submitted in this court, and we submit respectfully that the appeal court may see it differently, that delay that later happened because Mr. Pikoli prematurely charged when they still needed more information, more investigation. That delay is not attributable to Mr. Zuma. That's the first thing. The court deals with it, but we submit respectfully that the higher court may see that delay as a delay that was occasioned by Mr. Pikoli's premature decision. The second one is the decision about the court that led to the concession later, that entire litigation. Because that delay in our submission, it's attributed largely to Mr. Zuma and the NPA because they joined, and I'm using
the DA review application.
That review application. And I want to say this about that. First, the responsibility constitutionally to have a case heard speedily is that of the NPA. That's the first thing. And I'm not suggesting that the accused can do as he likes to do. I think my learned friend calls it Stalingrad approach, which of course was 5 months, 2 weeks, and 3 days historically. This was longer. I'm suggesting that the primary decision that the Section 35, the organ of state, is the primary organ that is responsible to ensure that it happens. Now, of course, in this case, the DA challenges the decision of the NPA. And we submit that, yes, Mr. Zuma is part of that because he's joined, and he joins it and he defends the decision. But what we are submitting is that to attribute that fight between the state for making a wrong decision, relying on a wrong provision. Yes, it favors Mr. Zuma. That I do not dispute, because they were withdrawing the charges against him. It favors him. But I'm saying we must distinguish between the fact that the decision of the state favored him and the fact that the decision was that the impugned decision is that of the state. And the state, whether at some point it had a head that agreed that the charges would be withdrawn, it's one state. To attribute that decision of the state to Mr. Zuma solely because it happened to be the decision that may have coincided with his interests or that he liked is not correct. Another court may find that the state takes sole responsibility because it was its decision primarily that was challenged.
But even if we were to say that the state should take responsibility for that delay, isn't it one of the delays that we'll probably call systemic? Because it was the DA that challenged that decision, and nothing could have happened in between that challenge and anything else for that matter. So everything had to come to a standstill, and hence maybe the conclusion that that decision is attributable to both because they were all participating in the litigation.
May I say this point, my lady? I think it's slightly different when an organ of state really takes a decision, relies on a wrong provision, and does not concede that early. The state.
Well, it's that's one thing I like about all senior counsel. They were all participating in all this wrong decision, And on that first day, most of them senior conceded on that. And now, when we have to look who was responsible, nobody, the senior counsel by the state, the senior counsel by Mr. Zuma, or any other person don't want to take any responsibility.
Well, let me take responsibility for this. I wasn't there, but I'll take this responsibility. I'll take this responsibility. There is absolutely no justification for lumping together a private individual joined by common interest, maybe, for that decision, and lump him together with a decision by an organ of state tasked with prosecutions, making an error of law like that, relying on a wrong provision. I think the NPA, even if we have problems with everything else Mr. Zuma does, I think the state, as the primary repository of that power, must take responsibility for that. And when he joins the state, of course he joins the state because any accused would join the state in defending the decision not to be charged. But the state, relying on a wrong constitutional provision, a state that is tasked with prosecution, is something the court should take a dim view about. And I'm suggesting that a higher court may well observe that Mr. Zuma was advantaged by that decision, but will not attribute it to him. It will say, you, the state, constitutionally tasked to take these decisions every day of your life as a state, you make such a schoolboy error of relying on Section 179D when you know what you should have done, and you probably do it all the time in other cases. I'm submitting that to make Mr. Zuma and the NPA co-responsible for a decision of the state may be a little too much for him as a private citizen.
But sorry, Mr. Sikakani, he's not only a private citizen. He is in that capacity. He is someone that was accused of certain crimes. I'm just focusing on and so we have to consider that he was part and parcel of the team making representations to Mr. Moshe. Mr. Moshe then making a decision, quoting a particular provision from the Constitution, and that being the wrong decision. Is it not human to err? I thought one of the greatest procedural lecturers taught me in my first year that to err is human, and that's why we have the process of review and appeal.
My lady, I'm trying to understand which part you want me to concede.
When you want to attribute to
the NPA,
the NPA,
yes,
in quoting the wrong provision, it is something that clearly, if we look at the law reports, happens many of times, not only in the NPA, but many judges interpreting certain provisions. I think
the only point I'm making is this: I'm not exaggerating the mistake they made, and I'm not saying it's uncommon.
yes.
I'm simply saying, and it really, I don't think it's appropriate to suggest that because this citizen was the president or the deputy president.
No, we never said that. I never used the word president. I said an accused.
Okay, I thought you
that
said it's not just a private citizen. Well, then my point is even clearer.
Yes.
The NPA must take sole responsibility for its decision, and to attribute it to a private citizen,
even though he participated up to the
absolutely.
SAC.
I'm asking that as we understand the conduct of the NPA, we understand it. We must also understand that an accused, we come here today, these two parties, finally this matter will be determined, always in an application for leave to appeal. Those who got the decision they like, defend it. And I do not think it should be something we don't understand, that an accused who's been told by a prosecuting authority that we are withdrawing charges against you would naturally defend that decision. And I think we must try and apply some understanding to Mr. Zuma that we do on the errors of the NPA. Because it's really understandable why a citizen who is accused would defend the decision, believing he's innocent, to withdraw charges against him. And I don't think it should alarm us that he supports that decision to the highest court. Then the next point we make, which we submit the higher court may look at differently. I think we started with this when we were dealing with the concession slightly. Is this, and I'm trying to persuade the court to see Mr. Mshe and the NPA as an organ of state making a decision. The decision that is reflected, which reflects the violations that Mr. Mshe was concerned about, that there had been, in his view, I don't use the word he used, but meddling, that there had been political interference. I read to the court in May a whole list of things that are unpalatable that were said and done, that we find in now what's in our documents, in the record, the spy tapes. And Mr. Mshe himself, if you read what he writes in that decision, forget for a moment that he used the wrong provision when he finally made the decision. But the reasons he sets out, read with what I read to this court, which is contained in the spy tapes, which we know, read with what we see in Hofmeyer's affidavit, those are submissions made by the NPA itself about itself. It says we were wrong. We allowed external interference in this. And I'm putting it to the court to consider, not to agree with me, because the court won't agree with me, but for this point only. There is reasoning that may be applied by another court, which may bind this court, is that those concessions and admissions of wrongdoing, of constitutional violations, and I call them constitutional violations because purely the independence of the NPA is found in both the Constitution and the NPA Act. And it is sacrosanct that the NPA must act in a manner that grants, that gives that institution and the work it does independence and integrity. And it doesn't matter how small it is, that someone took a political instruction one day. It doesn't matter, because it will happen when you and me are arrested. What we must protect the NPA from is temptation by anybody, a politician or a businessman or a journalist or an advocate, influencing how it does its work and how it functions. And to say, oh, this just related to time, excuses them too much and opens a floodgate for constitutional violations. We submit that whatever constitutional violations, breaches of your very existence constitutionally, that you must be independent, you must act without fear, favor, or prejudice. Once that is breached, as we see in the affidavit of Mayor admitting, and he was from the NPA, we see in Mshe, we respectfully submit that violation may be seen differently by another court. And another court may well, unlike this court, may well take the view, as I said at the beginning, that once you dirty your hands like that, and your premise is not the respect of the Constitution about your functions, the fact that you got one phone call from a politician should not excuse you. It should alarm us that a prosecutor, even once or half a second, took considerations that they shouldn't take constitutionally. And we submit that violation of the Constitution, the only way it can be justified is through a rigorous process of checking whether it's that right of the citizen who's being accused is limited in terms of the limitation clause. But as these violations in our view stand, admitted by the NPA, admitted by Mshe and Hofmeyer. Yes, I know they were criticized by the court, but those affidavits reflect their decisions and what they did. The spy tapes reflect the decisions of what they did. I submit that another court may well have no tolerance for that at all.
Mr. Sikakane,
Yes, sir.
since you are referring to the Moshe affidavit and the spy tapes and also Mr. Hofmeyer, isn't it true that at the time of the DA case, the 2018 one reported, that the SCA dealt with those issues as to whether this was an abuse of any process? And isn't it clear that we are bound by the decision of the SCA, the 2018 decision?
Let me distinguish this because I tried when we had this matter. The Haram stills, Judge Haram says he then was.
No, I'm dealing with the
later one.
Yes, the
Yes.
2018. I'm referring
The
to
DA one.
2018, where they dealt with the spy tapes.
Well, I think what we have now in the spy tapes that I read is a case to determine the impact of that political interference. That is what is before this court in a permanent stay context. That's not what was before that court to determine. What we brought to you, yes, it flows from there, but that court commented about that, but what it dealt with was a different matter altogether. And our submission is that when we bring this case, because they were not dealing with a permanent stay at all, in the context of a permanent stay, we submit that you are squarely empowered to deal with those violations in the context of a permanent stay. And I submit that that context distinguishes the role you were playing and the role the SCA, what the SCA had to determine then. No permanent stay application was before them. And I submit to you, my lord and my ladies, that you are empowered to deal with that separately from the issues that the SCA was dealing with. And therefore, those violations, in our view, should not be excused. And the court dealing with whether or not this process, this prosecution has been tainted by unconstitutional conduct. This court is empowered and is the first to deal with those violations in this context. The last issue that it doesn't relate to delay, it relates to Mr. Nguga's decision. And actually, Mr. Nguga's decision is intertwined with the decision first to announce that there is a prima facie case against Mr. Zuma, but he won't be charged. But central to that is the decision not to charge him with shake. And I think your paragraph 141 deals with this in the judgment. And I want to try and persuade the court about this. I know my learned friends from Thales tried to do this last time, but I'll repeat it anyway. The decision not to charge Mr. Zuma with shake has much more impact than is made here on his ability to face a fair trial in the future. Of course, a judge that is quoted here in the SCA says, well, it's not true that evidence admissible against this accused is not, or not admissible against this accused is the same would apply. Well, I would like to differ with that proposition because that theory itself doesn't take into account the nature of offenses that a court might be dealing with. The judge may well be right there that in particular crimes that is possible. And as a theory, it is possible. So I have no qualms with that theory. But when you have a document in a crime in an offense of this nature, where evidence is documented, the likelihood is really zero that the encrypted facts already dealt with by Squires JA as an example, in the SCA, which of course will bind the trial court. It will bind the trial court. What would be Mr. Zuma's chances in that court of challenging the evidence about which a higher court has made a pronouncement already?
So you mean that facts won't have to be proved?
The facts about a document.
Yes.
When the SCA has determined that the encrypted facts, for instance, demonstrates the corrupt relationship. In fact, this is said by the prosecutors themselves. Mr. Downer, they write that. They say, oh, aha, we've got it now. We've got it now. We are sure now because the Sheikh case makes our case even stronger, clearer. And they are right.
But it doesn't exonerate them from leading evidence. They still have to lead evidence. They can't transfer that evidence from that judgment into the trial court side.
Okay, let me narrow my case,
Yes.
because
Yes.
if I'm being understood to say
Yes.
there won't be a trial on
Yes.
anything, but I'm saying
Well, that is one of the submissions which we were taken quite aback, that the court might as well find Mr. Zuma guilty because it's in the notice of appeal.
no, I have. I don't think
You-
if you look at what will happen if you look at the trial itself, our submission, and I've apologized for this notice of appeal. But I accept that I'll take a flagellation once and not. But the point I'm making about it, maybe it may be exaggerated there. The point I want to make is this: is that, quite frankly, the trial court will have, in many respects, its hands tied behind its back in that trial, in respect of certain evidence about which Mr. Zuma would have liked to challenge, for instance. How could he challenge the encrypted facts? Now, after Squires said what he said, how could he challenge it? Suppose he did. He is not in the same courtroom with Sheikh. And what has happened is that the SCA, whose decisions bind the trial court that he will face, has made a pronouncement on what I submit may be the most critical component of what we call serious offenses by him, that charge. And when we make this point, and I don't want to exaggerate it more than it is that charging him with Sheikh would have made that possible to challenge that, and because the court itself would have had a benefit of his own views and evidence about that when it dealt with it. But it places the trial court in a predicament.
Mr. Sikakane, I'm trying to understand the submission because we're dealing here with a piece of documentary evidence. Once it is produced, it is still the onus on the state to prove that the requirements of admissibility was met, that the document should be accepted at face value. At that stage, when the trial is going on, the SCA's decisions, with the greatest of respect on that issue, is not something that should concern the court hearing the matter, because they're hearing it as the evidence gets adduced before it.
Just to add on this, it's still the task of the trial court to evaluate that evidence.
Yes.
To still evaluate it and decide and make its own decision.
On this point, I first disagree with the court, and secondly, I submit that another court may really see this differently. You've just told me a couple of minutes ago that there are decisions that bind you of the SCA, and I'm submitting to you that that decision in respect of that piece of document, by the decision by the SCA in relation to a document and its admissibility, what could Mr. Zuma say about the encrypted facts now that the SCA has made its finding about it? The trial court, in fact the state, will say, you, trial judge, you are bound. This matter has been determined by the SCA, this particular document. And we're submitting that by that decision, you limit the possibility of a fair trial. And another court may well disagree with this court on that aspect, that he faces a fair trial when he was not charged with Mr. Zuma, with Mr. Sheikh. We respectfully submit that even if you are right as you sit now, there are reasonable prospects that another court would not reason the way this court is reasoning about the limitation of possibilities of a fair trial by someone who's simply not charged because the state wants a dry run. You read the memorandum, you see that when Sheikh is now convicted, the prosecutors do say, aha, we've got it. It's tight. Our case is tight. And that, in my respectful submission, in a constitutional state, creates a situation of unfairness for the accused. You decide not to charge with the other. And I think the state should have thought about that more carefully. I appreciate that in your judgment, you do appreciate that it may have been better for him to be charged with, but I want to put it more strongly. I think it's not just it would have been better. I think that decision is much, much more serious, has much more serious consequences for an accused than than the judgment say. And another court may well see it as a limitation of a possibility of a free trial, a fair trial for an accused. But that's the sum total of the issues. There are different aspects that we raised of the delay, of trial prejudice, of all of this. And we submit that I've categorized them between the delay, the constitutional violations, and others. I want to persuade this court that even though I may have failed to persuade this court that it was wrong in some aspects, but I do think another court, in fact, there are reasonable prospects that another court will jurisprudentially approach these questions differently. And I'm not saying that because we have to get the order. I'm saying that because constitutionalism, the debate about constitutionalism is a much more bigger debate than the mechanics of many cases that we do. And I submit that the court must accept the possibility of another court, and that the high possibility that another court will approach those very, very points differently and may be annoyed and irritated by things that did not irritate this court as they did. And it's quite possible intellectually that those judges may engage with it, not better, but differently. And it will be a higher court. And my lord and my ladies, those are our submissions in this case. I've summarized them, but our heads deal with these aspects, and those are all our submissions. May I just
Yes, thank you.
I think we need to ask because we just want clarity. I think we should just leave it with this case.
Thank you.
Where's the court, please?
Thank you.
Mr. Katz.
Thank you, my lord, my lady. Yesterday, the court would have received our heads of argument, and we
Yes.
apologize for all the late time. They already observed that for personal reasons, not my other team that came last week. Now, there are certain aspects in the heads which, having discussed it with my learned colleague, Mr. Brayton, don't need to be argued, and I'll come to them as and when I raise the point. But there are 5 preliminary points that I just wish to raise before turning to the merits of Thales's application for leave to appeal. The first is, our application is a conditional application, and it's conditional upon the Constitutional Court refusing Thales's application for direct appeal to that court. Excuse me? No, I'll come to that. Testing. But we have a copy of that application were the court to require it. we don't believe it's necessary, but if we have 3 copies of that full application, including a reply.
We've seen the replying affidavit in the
Yes,
heads
but if
filed by
Yes.
the NPA.
But you don't have the founding or answering it.
No,
No.
that's true, but we've seen the reply,
Yes.
which deals with an abandonment of the state.
Well, that's the second point that I want to come to.
Yes.
The second point that I want to come to is that in the court's judgment, it deals with Tullis' application for leave to for a permanent stay in one paragraph and one paragraph only, and that is paragraph 150, where it is said that this court accepts that there was a delay in the prosecution of Tullis, one presumes an unreasonable delay, as that is contemplated in the Constitution. And then the conclusion is, but we are not satisfied that the delay would result in trial prejudice. And then the rest of the paragraph is explained why it is that this court comes to that conclusion, that what Tullis deduced by way of evidence would not result in trial prejudice. And originally in this
Sorry,
court...
Mr. Cook, but surely that paragraph has been read with what is being dealt with under the stay of prosecution that starts at 116.
Yes, in respect of...
Of what we were guided by in considering a stay of prosecution.
Yes, and we submit that the principles of law that this court articulated in Sanderson, Botten versus Else, etc., are not entirely incorrect. But we don't go there because I'm making one submission and one submission only. Bearing in mind the state's answer to our constitutional court application, we are of the view that it is still open for Tullis to argue trial prejudice at any lawful trial that it may face. And for that reason, we take up the invitation effectively from the state to abandon that part of our application for leave to appeal, and we place on record that we reserve the right to take any trial prejudice point that Tullis may seek to do at any lawful trial. So we place that on record. Coupled to that is, in our heads of argument, we deal with the question of appealability. And Mr. Breitenbach told me last night, and I hope I don't speak out of turn, that he's not taking the appealability point in respect of the review relief that we seek. We did deal with it in our heads of argument. We did refer to a judgment where we suggested that that judgment would indicate that it was not premature in the sense of appealability for us to have that review relief rejection not being regarded as appealable. As further by way of introduction, we accept for purposes of this case that the test for leave to appeal is that articulated in the various heads of argument filed by the parties. We agree with Mr. Sikakani that there would be an absurdity for this court to have to find that it was wrong in order to grant leave. That could never be the test. So we're attracted to the idea of, and we submit that it would be an attractive idea, is it plausible that this court's judgment might not be upheld on appeal? And that's from Hunter versus Financial Services. It's a reference made in Mr. Zuma's heads of argument to this court. So we would submit that the true test is it plausible?
Sorry?
Yeah.
Hey, can we take a short adjournment and see it's 1:15? We'll come back at half past.
I kept the part of my
Thank you, Mr. Case.
Thank you, my lord, my ladies. Before the tea break, I was dealing with the various preliminary points leading up to the merits of the application for leave to appeal. And the merits of our appeal are dealt with on page 13, paragraph 34 and following of our heads of argument. And we would ask that the court have regard to those paragraphs, and in particular the various what we call trite propositions that bear emphasis. And the first is that contained in a case called the National Society for the Prevention of Cruelty to Animals versus Minister of Justice, where the Constitutional Court in paragraph 31, we would emphasize this, said that the NPA Act gives effect to that power. And what is that power? That's the power to prosecute. And we would emphasize that it's legislation, as the Constitutional Court puts it, that gives the power to prosecute rather than that contained in section 179 of the Constitution. And we say it's important for other propositions which will follow, and in particular what we will call the subsidiarity principle. So it's the legislation, not the Constitution, that, open quote, gives effect to prosecution power. And perhaps I should just jump ahead, but what that means for purposes of our case is this, that where a particular official says, I am going to prosecute you, his first port of call is to the legislation and not to the Constitution. That's what the subsidiarity principle talks to. In particular, the case of called My Vote Counts, which I will turn to as one of my other trite propositions. There, a particular group went to the Constitutional Court and they said that their section 33 of the Constitution right was violated. And the Constitution said that's not how it works. You first go to the legislation. In that case it was PAJA, which, open quote, gives effect to section 33. The second trite proposition that we refer to is that contained on page 14. And there are two legs to it. The first leg is that when Mr. Abrams decided to prosecute Tullett and was challenged, and he gives reasons, not in affidavit but in a letter, it is those reasons and only those reasons that the respondent, the government, may rely on in defending a challenge to his decision. Similarly, and importantly, in the Liebenberg case, which I did refer to during the May hearing, as it was repeated in the Zuma versus DA case, the 2017-2018 case, paragraph 58 in particular, what that says is that where an administrative official relies on a particular provision for making a decision, it is that provision, and importantly only that provision, that he can rely on in defending a challenge to the exercise of that power. So if, as we submit happened, Mr. Abrams relied, as he did, and he says he did, on 179 of the Constitution, it's of no use to the state to say, well, he also had the power under section 22 of the NPA Act, and therefore the challenge to the exercise of his power on the basis of the powers point is without merit. This court could only look at, according to the Constitutional Court, section 179 and nothing else. So when this court had regard, by invitation by the respondents, to the National Prosecuting Authority Act, we submit that was inconsistent with binding constitutional authority on that proposition, what we call the Liebenberg versus Berg River Municipality proposition. I have already mentioned the subsidiarity principle, and perhaps I should just read from what the Constitutional Court said how it works. In paragraph 68, they suggest, the Constitutional Court, in My Vote Counts, that Parliament's argument is mistaken. It misconceives the nature of the challenge to PIA. It was an information challenge. Subsidiarity is inapplicable because PIA's constitutional validity is not in question. The principle does not assist Parliament, for it simply has no application. And this is important. Subsidiarity only applies when a statute's validity is at stake. Here, validity is not. PIA is not circumvented because there is no attempt to bypass. And then the important paragraph, which we've underlined, those are our underlining, paragraph 69. The principle provides that one may not rely, and we say importantly, directly on the Constitution in the face of legislation designed to give effect to it. And we put the words give effect to it in bold because those are the words that I've just read concerning what the NPA Act does. If you turn back to paragraph 35 of our heads, it says, and I emphasize what the Constitutional Court says, the NPA Act gives effect to that power. And what the Constitutional Court in paragraph 69 of my vote count says is, the principle of subsidiarity says that where one challenges something, you may not rely directly on the Constitution in the face of legislation designed to give effect to it. And that's exactly what Mr. Abrams has done. He has relied on a provision, 179. In other words, he's relied on a provision of the Constitution directly.
But that's a foundation of his authority. Is that not so?
Definitely not.
Why?
I've just explained, my lord. In the NPS, the National Prevention of Cruelty to Animals case says he may not rely on it when there is the legislation designed to give effect to that power. He may not. That's what this principle says. It says it in terms, in black and white. That if Mr. Abrams says, my power is in the Constitution, the Constitutional Court says, in our submission, he may not do that, paragraph 69 of my vote count. He has to go, in our submission, according to these authorities, to, and importantly, the legislation that gives effect to that, to it, in the words of my vote counts. One must treat the Constitution as subsidiary to the legislation for this purpose. So Mr. Abrams could have, and we might have had quabbled with it, said, I rely on section 22, 22.1, or 22.2, 22.9. But what he may not have done, according to this principle, is rely directly on the Constitution according to these two authorities. The fourth trite proposition, and we submit that these are trite, there's no debate about them. The fourth trite proposition is that contained in paragraph 39.
Well, I think that if we look at the heads from the NPA, then it is not so trite, Mr. Pass. If we look at the heads, it's not so trite. What you call trite may not be common cause between the parties, and again, it's based there on the interpretation.
So with respect, my lady,
what I don't understand with your argument is this: you want us to disregard what Mr. Abrams did because he relied on the Constitution other than an enabling act.
Definitely not.
Yeah. What are you trying to tell us?
That's not our argument.
What are you trying to tell us?
No, I'll come to that in a second.
I
My
think
argument is that
now.
on Mr. Abrams' version, he relied on the Constitution. I have to accept that. Let me answer, my lady. Your ladyship put it to me, it's not common cause. And one looks
I
at
said it's not trite. You said it's trite.
no, sorry, no, it's not trite. Let me answer it like this. There are 9 open quote points that the state rely on in order to deal with our powers point, 9. Once I'm finished my section of the heads, I will deal with all 9 propositions. And many of them, we agree with the factual conclusions, including that your lordship put to me, is whether or not Mr. Abrams, this court could find as a fact, if I understood the question, that Mr. Abrams couldn't rely on 179, factually. Factually he did, I accept that. It's common cause. So of the 9
that section actually gives him the power to issue the criminal proceedings.
I'll come to that as a different proposition. But whether it does or doesn't, he couldn't rely on it because there is legislation to give effect to that power. It's what my vote count says. It's not what I'm saying. My vote count says where there is a power, or in that case a right, granted under the Constitution, and there is legislation to give effect to that right, a party cannot rely, and these are the words, directly on the Constitution where there is legislation designed to give effect to that right.
I'm battling to follow your submission. I I thought earlier your submission was that Mr. Abrams relied on 179, and he ought not to have, because there's a legislation that
That's
he
what my
ought
vote
to
count
have.
says.
Sorry.
That's what my vote count says.
So is that
That's
your
your submission, yes.
Because
One
that's
of my
what we want.
submissions.
That's what I think my brother was
Yes,
asking,
no.
and we want to understand that.
Factually, as a fact, I accept that Mr. Abrams relied on 179 too.
Yeah.
I accept that. There are certain consequences that flow from that fact. But before I get to those consequences, I'm setting out what we call trite propositions. I know that our learned opposition takes a different view as to how the consequences flow from those propositions. But the propositions are trite. That's the point. Justice. Then the fourth proposition is that just as under the common law, the interpretive exercise concerning the meaning of a provision of an Act of Parliament, regulations may not be invoked, and we reference an appellate division case of 1989, Moodley versus Minister of Education. Similarly, we say, under the Constitution, under the constitutional scheme, what cannot happen is for a court to interpret the Constitution with reference to legislation. Never. It's trite. It goes back to the first constitutional interpretive exercise ever, not just in this country, but throughout the world. One cannot interpret the Constitution through the prism of subordinate delegated legislation, or legislation, in the words of the Constitutional Court in this case, to give effect to 179. And I don't believe that our learned friends argue differently. They don't. And I invite the state to argue, I invite them now, to argue that a court can have regard ever to legislation to interpret a constitutional provision. I invite them to do so. It's key. And we say so in the last sentence of paragraph 39. An Act of Parliament cannot be used as an aid interpreting the Constitution, and there's reference to the judgment of Damaseb, it was CJ or Muhammad AJA in the Supreme Court of Namibia at the time. It goes back to all constitutional interpretation throughout the world and throughout time. One cannot have regard as an aid to interpreting the Constitution to legislation. And I invite our learned colleagues to suggest that my submission as that proposition is wrong. But that's exactly what this court did. And one turns to paragraph 163 of the judgment. What the court says is it is necessary to closely examine and interpret the provisions of the NPA Act that empowers the NDPP to exercise its powers, duties and functions. Let me stop on that sentence. That sentence in and of itself suggests that, and we use the words of Hunter versus Financial Services, that it's plausible that another court may take a different line on this argument. This court had one particular exercise to adopt, and that is to look at what Mr. Abrams said. He said 179.2. That's what he said. That's the Liebenberg proposition. And then this court had one duty, and one duty only, to interpret 179.2, not look at the NPA Act at all. It had no power to do so. And we submit it subverts what we call trite constitutional propositions concerning the interpretive exercise that goes to the Constitution when it comes to the kind of argument that is put up by Tunnels.
Mr. Katz, your interpretation is that the court is here busy with the constitutional exercise, but surely one should read the judgment in its entirety, because it deals in particularly, if I look at 162 on page 59, with a particular section of the NPA Act and how the Thales went about in interpreting that part of the Act. Forget about what was, at this stage, if I look at the judgment and reflect back, it deals with the NPA Act. Now, where in this exercise is the court dealing with the Constitution and the interpretation of the Constitution?
It doesn't.
Yes.
Fundamentally, a mistake that this court made with respect.
Well, that is the submission made by Thales, but you equate 163 as if the court is looking through the prism of national legislation in interpreting the Constitution.
That's correct.
Yes,
And
which it's not saying that.
Well, it says exactly that with respect. The words say what they mean. They say, this court finds it necessary to closely examine and interpret the provisions of the NPA Act that empowers the NDPP to exercise its powers.
Yes, but it deals with section 22 sub 9.
Correct.
And then it goes on.
Correct.
So you see,
Correct.
I think one can't just give and look at the judgment and read every paragraph in isolation. You have to look at it in its entirety.
Correct. And one looks at it in the entirety. One looks at 161, where your ladyship took me to. It all deals, there is nowhere in this judgment that I see a consideration of 179, and particularly 179.2, read in context of the other provisions of 179, without reference to section 22 of the NPA. And indeed, in conclusion, this court finds in 167, exactly what I've just said. We are satisfied that Mr. Abrams had the power in terms of 179 and 22.1. You may not say that. That in and of itself is a fundamental error on all the four propositions that I've put to the court. The first is that 22 is irrelevant. The court may not have it
You
on.
referred us to 22. When you were arguing here in May,
Understand your argument.
we were
Mr.
busy
Katz.
with in person or not in person. That is from 22.
Must be yes.
So you referred, we must take into account the submissions that you made before us. We had to deal with that submission that you made.
Yes,
I'll
that's
make
what
one
you
proposition.
told us, Mr. Katz.
In my
Unless we have a change of heart. I mean,
never
that's
changed
what
my
you told.
heart. In
Yes.
my address in May, I made the submission that Liebenberg versus Berg River means that this court could only have regard to that which Abrams said. And Abrams said 179.2.
I think you need to relook into your heads of
I've
argument.
looked at
Yes, yes. I think you need to do that.
No, but with respect, we said, in response to the state's argument that 22 could be used, whether it be 22.9 or 22.1, no, you could only go to 179.2. That was the submission.
Yes, anyway,
stand on
you've
that
made your point. I think let's move on.
And it's a
Let's move on.
fundamental difficulty with, we respectfully say, is part of the judgment. If the state tell us now, well, there's some other judgment that I don't know of, whether this court is entitled to look at section 22 of the NPA Act, then I would have to accept it. But there is no judgment ever, anywhere.
My understanding, and I respect what my brother says about moving on, but as I understand it, it was from the reply by Thales that Abrahams ought to have or relied on 179 and not 22.
No. No, that's with respect to that.
But
This is what happened.
can I even pause there, Mr. Katz? You know, I always believe that black on white is a good thing to have with you. You would concede that you handed to us Thales' note on oral argument.
I accept that.
Yes, so this was very much part of your
And you
submission.
didn't want to take it in if I remember.
And
Just wait, Mr. Katz.
I'm not
Wait
finished, Mr. Katz.
for her to finish,
you
please.
see, you can't now tell us, because you have at length deal with how section 22 ought to be interpreted. In fact, you know, should it be disjunctively, should it be conjunctively?
Yes.
In your own submissions now, in order to deal with everything that was said, how did you expect this court not to consider section 22 sub 9?
So, sorry, with respect, and let me answer it very simply. That note on oral argument was filed in response to the state's submissions that they could rely on 22. And we said they couldn't, quite apart from the 179.2 argument. It's not, I think it's grossly unfair with respect, and I'm only talking fairness to me, but I made the argument. I referred in terms to Berg River, Liebenberg. I read it to the court. Jafta's judgment, and if the court wants me to read it again, I will. I read it to the
please
court,
don't.
and I said to the court, that's the only power that one can look at, 179.2. This court didn't touch Berg River in the judgment. It's not mentioned. And I read it to this court in detail. So with respect, it's unfair to me to what I would submit is mischaracterize what I put to the court in the way that I put it. What I said was, in the alternative, the state come up with a new argument, which they're not permitted to do, which was to rely on Section 22.
But your submissions, as I understand it, is that we ought not to have made any reference to 22 or the NPA Act, but only to the Constitution.
On the basis of the following.
Yeah. No,
We
got
understand
that.
that.
So,
And to do so, sorry, with respect, Justice Potter, to do so is inconsistent with what we regard as trite constitutional principle. And we invite our learned friend to indicate a case where legislation has been used ever by the Constitutional Court or the SCA to interpret a constitutional provision.
Did we do that?
Number one, that's the first proposition. And to the extent that this court looks at me with a sort of askance, if that's the word, to suggest, well, what am I talking about? What I submit is that on these propositions, there is at least a plausible argument to be made that this court got it wrong. We submit this court clearly got it wrong on that reasoning, to have regard to Section 22 of the NPA Act in interpreting Section 179.2. But even if your court doesn't agree with me, and I can't expect the court to agree with me because this is what the court did, there is a plausible argument, in the words of Hunter versus Financial Services Board, that an appellate court may agree with my argument on that reason. I turn to the substance of my 179.2 argument. It has two parts to it. Because if this court agrees with me that the NPA Authority Act wasn't available for this court to use, that doesn't get me home necessarily. Because then I've still got to convince the court that Abrams' own invocation of 179.2 led to an unlawfulness. And I have two bows to my string there. The first is subsidiarity. And subsidiarity means that an official who relies on power where there is legislation, in the words of the Constitutional Court in the SPCA case, designed to give effect to that power, may only, my vote counts, go to the legislative grant of power, not to the constitutional power directly. That's what it says. That's the first leg, my first bow to my string, if the court accepts my proposition that the court only could look at 179.2. The second leg to my bow, second bow to my string on that, is that 179.2 as a package, even if it could be looked at directly, and this is if the court rejects the my vote counts, rejects the NPCA case, if it rejects those submissions, then it's got to come to the following conclusion. 179.2 on its face gives that power to the NDPP. And we submit that 179 as a whole, and the court has to look at 179.3 in particular, which we referred that to in our heads of argument, and 179.7, all point to one conclusion and one conclusion only, and that is that what 179.2 does is give the NPA as a whole prosecutorial powers. And then what it also does is it points to certain specific powers that must be dealt with through national legislation. So if one has regard to 179.3, that's the power, or the grant of the power to DPPs to exercise prosecution powers granted by national legislation. And it says 179.3 subject to section 179.5, which is the grant of the specific powers to the NDPP. Now, learned friends, and I'll turn to this, talk to 179.7. And importantly, we make the point, 179.7 deals with other, and it uses the word other, prosecutorial. all other matters.
Yes.
Meaning other, not those contained in 179.3 or 179.5. So the state's reliance on 179.7 is misplaced if one has regard to it as a whole. So we would submit that the second bow to our string also has plausible prospects of success on appeal. And we would submit that for this court to close its eyes to the possibility that 179 does only that which we say it does would be to misapply what we would call the appropriate test for leave to appeal and on other compelling circumstances. And I must turn to the 9 propositions that our learned friends rely on in answer to what we would call this challenge. On page 38 of our learned friends' heads, in paragraph 76, they set out the 3 contentions that Thales puts before the court in this application for leave to appeal. And they set out the 3, and then they say in 77 they submit in no merit. But may I just take the court to the 76, 1, 2, and 3, so that the court can see how the state characterizes our argument on this point. The first is, the court was wrong to find that 179.2 conferred on the power. That's correct. That is our argument. B, the court was wrong to find that in addition to 22 conferred that power, because according to Thales, the only power in the Act was 22.9. That's not our argument in the leave to appeal. We say it's irrelevant. So they've mischaracterized, in our view, what our true argument is. 76.3, in any event, Thales alleges the state could not evoke 22.1 because he did not do so when he took his decision or in his answering affidavit. We accept that. That's perfectly correct. And then they start off in 78 with 9 reasons. And perhaps I need to deal with the 9 reasons, because each of them we would submit are either irrelevant, wrong, or they support our contention. So we have 9 propositions, and they fall into 3 categories: wrong, irrelevant, or they support. The first 2 are in 78 and 79, and they refer to the 2 SCA decisions. The one was Haram's DP, and the other is NAFSA, the October 2017 decisions. Let me emphasize, both of those decisions did not deal with the current challenge. So anything that was said about whether and share or anybody else dealt with the institution against Mr. Zuma, Mr. Sheikh, or Thales lawfully under 179.2 is utterly irrelevant. It's arbiter, and we emphasize, in any event, if one has regard to what is said further down in the Haram's DP judgment, he sets out, and we've quoted it in our heads, on 75 of our heads, we say, in that decision, the SCA explains how the NDPP exercises this oversight, stating, and then there are various issues in paragraph 59 of the SCA decision. Nothing to do with our case or our propositions. But then in 76, this is what he said. Thus, on the authority relied upon by the respondents, the responsibility that the NDPP has over the prosecutorial service in South Africa are, in the words of Haram's DP, and this is the important proposition, to determine prosecution policy. We accept that. To issue policy directives. We accept that. And to intervene in the prosecution process when policy directives are not complied with. We accept that. So not only is the reliance on Haram's DP's judgment arbiter, but it's also wrong, because Haram's DP sets out what the NDPP's powers are, and they don't include what Mr. Abrams did, which is to institute prosecution. So it's arbiter, irrelevant, and wrong. And I turn back to our learned friends' heads in paragraph 81. And those similar propositions apply to the judgment of NAFSA, TJP at the time, in October 2017. He was dealing with a review of the decision to withdraw. He wasn't dealing with the institution of a prosecution. And as a fact, if that's a the powers concerning prosecuting authority which must be determined by national legislation made in terms of 179.7. We agree. That's under 179.3 that we refer to. So we agree with our learned friends. It's not an other matter. It's already dealt with in 179.3. It's the first time I've seen this 179.7 argument, and it's plainly wrong. It says the doctrine of subsidiarity, and he says, assuming without conceding that it operates the sphere of legislation, accordingly does not preclude reliance on 179.2. That's a conclusion without reasoning, with respect. So 179.7 is misplaced for purposes of the subsidiarity argument. So we submit that the third reason is similarly fatal in that respect. 4, paragraph 82. In all of the relevant contemporaneous documents, Mr. Abrams says 179.2. Same proposition is made in 83. Fifth, 179.2. We agree with 82 and 83. And that kills them on the Berg River proposition. They say Abrams relied on 179.2. We agree with them. That's our argument. How can that be as a counter to our argument on the issue? If so, 2 of the 9 propositions we agree with entirely. And on the Constitutional Court authority, which we say is trite, it's been upheld by the SCA, Berg River, it's of no use. In fact, it's against that. Then we turn to 85. 6. Section 22 of the NPA Act, to which the state also referred in the heads, when the court knows that one can't do that, and to which this court referred in the context of the judgment, does not detract from the power to institute. Now, we submit that argument is of no use to man or beast. Section 22 cannot be used to say, well, 172.9 does this or doesn't do that. That argument goes nowhere. It's what he says, its function, the last sentence, is to affirm the NDPP's powers to manage and control all members of the NPA, which is what Mr. Abrams was doing, directing at the DPP, which facilitated. That's not what he did. That's just simply wrong on the facts. He wasn't facilitating anything. He made a decision to institute the prosecution. So the 6th proposition is simply wrong, as a matter of fact and pleadings. The 7th proposition, the state cannot be faulted for not referring to Section 22 in its answering papers, which it didn't. It did not. I invite my learned friend to point anywhere in the answering papers to Section 22. It doesn't exist. The court can do a computer search. Those words, Section 22 of the NPA, do not exist in the answering papers. And then it says, I've got it. It's correct. He says for not referring to Section 22. So they didn't. So they did not refer to Section 22. So there's an acceptance of my proposition.
Okay, can we just, one aspect I want us to have consensus as to what is tried. One will answer to what is in the founding. Yes. So if something is raised for the first time in reply, the vote has said.
Absolutely not in a case like that. Sorry, with respect, Justice Steyn, this is the issue. In our founding papers, we challenged the validity of the decision by Abrams. It's a review. At that stage, it is said in terms, we do not know which power he relies on to make the decision. We didn't know. The court will recall that in rejecting our representations, he did not say, I'm rejecting them in terms of this section or that section. So we didn't know. In our replying affidavit, we learn for the first time what power he relied on in the answering affidavit.
But did you say he relied? Oh, sorry.
So
He
my
relied on that on the letter.
Yes.
So
And my concern also is this, that you seem to be engaging in replying, on what is stated in the state's heads of argument. I don't know, because you will have an opportunity of listening to the arguments and reply, given an opportunity to reply on whatever they say.
I've got two to go.
Yes,
Maybe I should
yes. I think you. Yeah.
Well, let me just
I think
finish.
that's a proper way of. Let's do it the proper way.
I always give. I think it's only fair to my learned colleague. The 8th and 9th propositions we agree with entirely.
Yes, but I'm saying to you, let's stick to the rules of the game.
If you, I'll argue as you directed.
Yeah.
So what we submit is this: the question of the invocation of a power is a matter of law that can be argued from the facts. It's not a factual issue that is in dispute. The facts are not in dispute in this case. So it's got nothing to do with the founding, replying, answering affidavit. It's a legal proposition, and from Swissborough and the SCA, the legal proposition is, what was the power that Mr. Abrams relied upon? He told you, and the NPA tell you today, he relied on 179.2. That's the power that they relied upon. It's not an issue. Just a statement with respect. So it's not a question of pleading. That is the power. And all this court has to do is decide, did Mr. Abrams have that power or didn't he? And was, quite apart from that, he entitled to rely directly on that power when there has, in the words of the Constitutional Court, put in place legislation to give effect to that power. That's the argument. You may reject the argument, but it's plausible that it's a good argument. You might not like it, but that's the argument. And we submit twofold. One, to summarize, conclude, he was not entitled to rely on that power on the basis of subsidiarity. And two, 179.2 on its face, in context, history and purpose, does not give the NDPP the power that Abrams invoked to prosecute Tallis. It's a very simple proposition, very narrow, and let me emphasize, we accept, for purposes of argument, that the test may be higher on the reasonable prospects of success, for purposes of argument. But the second tag to leave to appeal, other compelling reasons, circumstances, we would submit, clearly this point falls into that category. Clearly. This is the first time that it's ever been determined what the remit of 179 is for purposes of this type of issue. The prosecution power is a massive power. It can be used, as we've seen, court can take judicial notice, to cause havoc in different societies in different ways. And the history, purpose, and context of this provision in respect of this massive power, we submit, needs to be considered by the appellate courts of this country, bearing in mind our plausible argument based on tried propositions. They might not agree, I accept, the state might not agree with the consequences of those propositions, but those are the propositions that the Constitution has set out. And we submit, just on the powers point, I'll come to the prosecution policy and rationality point in a second. Just on this powers point, leave to appeal should be granted. Marlena Jr. reminds me that in this argument, I haven't referred, which is in our heads, to the 179.5 issue, which is 179.5 itself sets out specific powers granted to the NDPP, and none of them include the decision that Mr. Abrams took. And if one reads 179.5, those specific powers granted to the NDPP, together with 179.3, in particular 179B little 2, which gives powers to the DPPs in respect of specific provinces, we submit that contextually the argument is, in the words of Hunter, plausible that the SCA would agree with our argument. accepting that this court might reject it, another court may agree with our interpretation of 179. And on that point, I don't want to leave it. If we are wrong, it does seem anomalous, we say this in our heads, that there are certain classes of accused who get the right under 179.5, subject to the legislation, of course, it's under the legislation, to review the NDPP. Not to review the NDPP, to review the decision to prosecute. So if the DPP takes a decision to prosecute an accused, we know from all these judgments, and we know that that accused has a right to review. Why should a class of accused, which is the class that would be prosecuted by the NDPP, be denied that right? And that's effectively what an interpretation that would go with the state's argument would amount to. So Mr. Abrams takes a decision as the NDPP. That accused, unlike all other accused, would not have a proper right of review as other accused would have from the DPP up to the NDPP. And it's absurd to suggest that the NDPP can act as his own appellate or review body in respect of his own decision. We make that point in our heads of argument. So contextually, purpose, history, and what we would call logicality determine, not that we're right. You don't have to agree with us. I can't ask you to. You've already rejected the argument without having actually delved into 179 with respect. But that there is another court that would consider these arguments and actually agree with us. And to reject them, to reject the possibility of the plausibility of the argument, we would say is not an approach that this court should adopt. Just on the powers point. We turn to the prosecution policy point and the rationality point. In some ways, they blend into each other. I accept that. And I must also accept, as I do, that it's a different type of challenge. Because there, in the first challenge, it's an objective, it's not a pleadings point. Because there, in this first challenge, the powers point, it's a matter of law. Who has the power to prosecute and in what circumstances? When it comes to who, it's purely looking at the law. This is somewhat different, and I have to accept that. So when your ladyship puts to me, where was it raised? And I would accept for purposes of this debate that if we hadn't raised, for example, the prosecution policy in the founding papers, I might have some difficulty. I have to accept that, because it's not a pure law point in the true sense. It's a question of Mr. Abrams assessing certain facts, coming to a conclusion on the basis of those facts, and then we say those facts are irrational or in violation of the prosecution, binding prosecution policy, and then this court assesses that decision of it. It's different. It's not a strictly legal point like the 179.2 point. So I have to accept that. And our arguments are quite simple when it comes to prosecution policy. And they're narrow. Different to the 179. They're narrow. The argument is this. The state accepts, as this court did, that in order for Mr. Abrams to have done what he did, he had to have special reasons. That's what 4B of the prosecution policy tells every NDPP. And the only question is this. Can it be suggested, and we submit not, that a special reason can be the reason that Mr. Abrams relied upon, which is simply that 9 years ago, his predecessor acted unlawfully. That's his simple reason. And then you add in the rest, but the rest are irrelevant, because the rest are, they have a strong case, they have a prima facie case, etc., etc. But those propositions, the strong case, important or serious offences, they all applied in April 2009. So in April of 2009, Tullis wasn't accused. That means that the NPA or the NDPP or the DPP must have taken, and they don't suggest they didn't, the view that they had a strong case against Tullis in 2009. They also must have taken the view in 2009 that these were serious charges. And we don't quibble with those propositions. So the only special reason that can exist is not because these are serious charges, not because they have a prima facie case. It can only be, logically, that there was some event that took place 9 years ago, 9 years before March 2018, which in some way made this a special case, a special reasons case for them to reinstitute. That's the case. This court found that the special reason was the benefit that Tully's received by the withdrawal of the prosecution against it. We submit, another court may, that it can never be a special reason for a narrative similar in the sense that it's plausible that another court might disagree with this court, that it's not a benefit as this court would have it, as argued by the state, but rather it's not a special reason. Rely on your own unlawfulness to do something which violates rights. Give me no doubt that there was a violation of some rights here. Leave aside trial prejudice. To withdraw against an accused and then 9 years later to reinstitute cannot be anything other than a violation of rights. And the only question is there a special reason for that violation? And the question then becomes, well, is your own unlawfulness to be regarded as such a special reason? And to defend that unlawfulness for 9 years and be so that one. When it comes to rationality, the third leg of our challenge, similarly, it's a different type of challenge to the powers clause. So it's a question of legality, and yes, it must be determined objectively. I accept that. But if we haven't made the case in our founding papers, we might have some difficulties. It's a different type of issue. But what we make out in our papers is this. On Mr. Abrams' version, he said the following. He said that one of the reasons irrational, it crashes the whole decision on the basis of platinum mines. There were 5 reasons given for dismissal of an employee, and Cameron J. said, well, if you've got 5 reasons, one of them is bad, the decision goes. And one of the reasons for the purpose of rationality is Mr. Abrams saying the following. He said he knew that Tullies would complain about an unreasonable delay. He knew it. But he said, well, I'm going to reject their representations on bench prosecution against because he knows, and they probably would and could, bring a court challenge to my decision. 81.4, he's answering after that, paragraph 81.4. This court accepted that as part of a rational reasoning process. We submit that it can never be rational for any decision maker to say, I'm a liquor board. I refuse a liquor license to Mr. X because I know that he's going to disagree with my reasoning. It could be a racist reasoning, it could be the worst reasoning in the world, it doesn't matter. But I know that it doesn't matter because he's going to take me, he can, could, and would take me to court, and that court can decide. And that's what Mr. Abrams said. And that can never be rational. He's going to take the decision as if he believes it's the correct decision, and it's irrelevant in every way whether Tullies could and would take that to court. And to the extent that he factors that into his decision-making process, his decision is clearly, in our submission, objectively irrational.
Mr. Katz, I was on this court. I've noted in your head you refer to the prospects of successful prosecution were not raised at all by Tullies. Its representations related to the unfair trial prejudice that it would suffer if he were to be prosecuted. But at all times it was also a common course that Tullies did not disclose what was placed before Abrams and what he decided on.
No, sorry. What happened was this. If I remember correctly, we had this debate at the time. Tullies made representations to Mr. Abrams and they were rejected. The rejection consisted of a letter in July 2018, and included in the letter were reference to offences that didn't exist. And there was one sentence or one paragraph in which Mr. Abrams said, I reject the representations because I have a reasonable prospect of a prosecution. That was his only reason. That's what he says. I can't, and that's, with respect, the first trite proposition that I referred to earlier with reference to the National Lotteries Board. He is bound by that reason. And with respect, I did argue this before, and that one sees in paragraph 36 of our heads, paragraph 24 of the SCA decision, where what NAFSA DJP says is, on April 29, Mr. Mshe announced
That NAFSA DP, please, he's not no provincial division, the deputy judge president. I think he will take umbrage if he has been referred to as that.
as that.
He's not a deputy judge president, he is the deputy president.
Acting deputy president.
He announced publicly, this is Mshe, that he had made the decision to discontinue the prosecution of Mr. Zuma and issued a detailed media statement providing the reasons for the decision. And then the important point, and we've made a footnote there to National Lotteries Board, this is NAFSA DP. It is against those reasons, and importantly, and those reasons alone, that the legality of the decision to terminate is to be determined. So what one can't do, and Justice Whitey and I had a debate about this on the first day I argued, one can't do is look at any expanded reasons that he gives in his answering affidavit. It's the reasons that he puts in his letter. That's the proposition that National Lotteries Board set out in 2012, adopted by NAFSA DP in the Zuma case. You look at those reasons and those reasons alone. But I'm making a further point, which is that even if you reject that submission, and you look at what he says in his answering affidavit, which is different to what he said in his letter, it's expanded. Let's accept that. So you reject my first proposition. And now you turn to my second proposition. What did he say in his answering affidavit? He said what he says in paragraph 81. And in paragraph 81.4, he offers this court a reason which we submit, and it's plausible that another court will agree, is irrational. That's the submission. And if we are right on that submission, then we must succeed only in respect of paragraphs 1 and 2 of our notice of motion, not paragraph 3. Now let me stand back and look at Tully's application with some distance. There are 3 propositions that we put before the court. The one is the powers point. And we say, as a matter of law, leave aside the pleading, as a matter of law, the only provision that the state can rely on is that contained in the letters. 179.2. The state agree with us. And I've invited them to explain how it could ever be that the NPA Act could ever be used as an aid to interpret that provision, which is what this court did. Number 2, Mr. Abrams wasn't entitled to rely, my vote counts, directly on the Constitution. He had to, as my vote count suggests, go to the legislation, the National Society for the Prevention of Animal Cruelty case, the legislation that gave effect to that power. He had to, but he didn't. So we win on that point. If we are wrong about all that, then we go to what 179.2 says. And we say it doesn't give the NDPP the power that this court found was somehow contained in it, read with section 22. The second argument, if we're wrong about all that, the second argument, special reasons can never be. I acted unlawfully 9 years ago. I defended my unlawful action. 9 years later, I go and violate rights. That can never be a special reason. But leave aside prosecution issues. In any administrative, executive lawmaking position, that you yourself as the state can act unlawfully and rely on your own unlawfulness to violate rights. But this is what this court found, with respect. And then the third reason is, let's call it, which the second reason morphs into. It's separate, but there's a certain intersection. is the irrationality argument.
Are you recapping?
I'm just summarizing, standing back, what the case is about. So I've given the 3 heads of argument as to why Mr. Abrams' decision must fall. Paragraphs 1 and 2 of our notice of motion. But all 3 don't need to be proved. If I'm home on one of them, or one of the tributaries of one of them, I'm home. So even if this court doesn't like any of the arguments, the submission is it's plausible that one of them may be accepted by a higher court. And for that reason, leave to appeal, we say, falls to be granted. And as far as the other compelling reasons is concerned, we say in our heads of argument, in particular, and we emphasize, the powers point needs to be decided by the higher courts. This court hasn't grappled with 179 on its face. And if ever there is a case for a decision to be made finally by the higher courts, it is this decision. What are the powers of the NDPP? This country cries out, I read every day, Court can tell you what's happening with prosecution, state capture, Estina I read about yesterday. Patoyi and Cronje go on TV on Tuesday.
I don't think we need to go into...
No, we didn't, with respect.
I don't think...
With respect. Who has the power? Not the president, not the executive, somebody part of the NPA, and who within the NPA. And we submit that it would be not comforting, and I use this word loosely without being disrespectful, to find the final word on who has that power is with this court. And that the issues are far wider than this NDPP, this Tales, this Mr. Zuma. It's an issue which will govern prosecution issues going forward for the next 50 years. Who has that power, this massive power? It's an issue of law which the higher courts must, we submit, determine finally. It shouldn't be left to one court to determine this massive issue as it pleases.
Thank you.
May it please the court. With your leave, we intend dealing first with Mr. Zuma's application for leave to appeal.
Yes.
We intend addressing the following issues. The first is the reasonable practice of success requirement in Section 17 of the Superior Court Act. The second is Mr. Zuma's main contentions on the merits in support of his application for leave to appeal. And in that regard, as we understand them, and this is based on the written argument submitted to the court yesterday and on an oral argument today and a brief discussion I had with my learned friend during the short adjournment. I had the discussion because some of the points taken in the heads were not persisted with, but he informs me that all of the points in the heads are being persisted with. The first then is Mr. Nguka's August 2003 decision not to prosecute Mr. Zuma together with Mr. Sheikh. The second is Mr. Pikoli's June 2005 decision to prosecute Mr. Zuma. The third is the Browse Mole investigation. The fourth is Mr. McCarthy's discussions with Mr. Nguka in late 2007. The fifth is the responsibility for the delay caused by Mr. Zuma's challenge to the August 2005 searches. And the sixth and final is the court's finding in the judgment at paragraph 150 that the seriousness of the offences that Mr. Zuma is facing outweighs any prejudice which he claims he will suffer if the trial proceeds. The first four of those are the factual underpinnings for the claims of constitutional violations and abuses of power by the NPA on which Mr. Zuma relies. We shall address argument to you as briefly as possible on each of them. We shall also consider very briefly the implication for the requirement in section 17(1)(a)(2). That's the requirement, some other compelling reason why the appeal should be heard, of the fact that the two applicants before you today have adopted different procedural courses. Mr. Zuma is applying for leave to appeal to the Supreme Court of Appeal alone. TAL is applying for leave in the Constitutional Court for leave to appeal to that court, and its application today is a conditional one. It seeks leave, but if we understand its position correctly, it will only persist with the appeal if leave is granted, if the Constitutional Court refuses its application for leave to appeal. We wish to address you briefly on the implications of that for this very voluminous matter, if it is to go further, the question of whether the two cases should be separated, and secondly, the issue of whether in the particular circumstances of this case, having regard to the findings of various differently constituted panels, admittedly, of the SDA, whether the interests of justice or a compelling reason, to use the words of the statute, point towards an appeal first to Bloemfontein and then, as Mr. Zuma's legal team have indicated, to Johannesburg, if that is unsuccessful. We shall deal also briefly with Mr. Zuma's contention that this court should not have made a costs order against him in the main application, which is being persisted with, I'm told. We wish to make certain brief submissions about the costs of this application by Mr. Zuma, the present application for leave to appeal. And lastly, we also wish to make some brief submissions about Mr. Zuma's contention that this court shouldn't have been constituted as it is, but rather as a single judge. In making those last two sets of submissions, we are mindful of the exchanges between the bench and my learned friend for Mr. Zuma earlier today. Dealing then first with the test to be applied, the reasonable prospects of success requirement. The governing provision is section 17(1)(a)(1) of the Superior Courts Act. Now, I shall from time to time be referring to authority. We have prepared a truncated bundle, the head notes and relevant parts of the cases to which we refer, as well as one additional unreported SCA judgment on this point, which we came upon very recently, yesterday in fact, when preparing. May I ask the court's leave to hand that up? Now, as the court is well aware, section 17(1)(a)(1) of the Superior Courts Act provides that leave to appeal may be only, and we emphasize the word only, given where the judge or judges concerned are of the opinion that the appeal would, and we emphasize the word would, have a reasonable prospect of success. And our first submission is that the Superior Courts Act has raised the bar for granting leave to appeal. Whereas the former test under the previous Act and Rule 49 was whether another court might, that was the operative word, come to a different conclusion, the word would requires Mr. Zuma to show with a measure of certainty that the SCA will differ from this court on his intended grounds for appeal. Now, in that regard, we refer you to the case of the acting NDPP, which is in the bundle. The report, it starts at page 53, and the relevant passage is at page 65, paragraph 13. And we refer this court to that passage for a number of reasons. The first is, as the court will see, this was the application for leave to appeal by the acting NDPP and Mr. 53 in the bundle, yes. It's acting NDP of Public Prosecutions and the DA. The page numbers are on the top right hand.
From page 64.
Yes, the judgment is at page 53 and the relevant passage is at page 65. This was the judgment in the application for leave to appeal by the acting NDPP and Mr. Zuma against the High Court's finding in the spy tapes case. aside from the passage to which I am about to refer, the court will see that many of the issues raised in that application are similar to the issues raised today. And that's relevant to a submission that I'll make later in relation to 17182, another compelling reason. But for now we refer to what is stated by the full court, the Deputy Judge President in the Gauteng, and citing a judgment of Bertelsmann J. sitting in the Land Claims Court on that occasion in Montchevaux Trust. It is stated, it's clear that the threshold for granting leave to appeal against the judgment of a High Court has been raised in the new Act. The former test was whether leave to appeal should be granted was a reasonable prospect that another court might come to a different conclusion. The use of the word would in the new statute indicates a measure of certainty that another court will differ from the court whose judgment is sought to be appealed against. Now that dictum has been followed on several occasions by single judges in this court, and we have given the references in our heads of argument. Now, we would emphasize that absolute certainty is not required, but equally a possibility connoted by the previous test might will not suffice. The grounds of appeal must, we agree, be plausible, and we are fortunate that in the loose judgment in your file, the MEC for Eastern Cape and Mkita and another, the Supreme Court of Appeal has elucidated what is meant by this. Now that was a hopeless appeal, and at the end of the judgment, at page 6, paragraph 16 and following, the court felt constrained to issue a warning to high courts not too readily to grant leave to appeal. And there is first a reference to the provision that we have just been discussing, and the word would is emphasized in paragraph 16. Then in paragraph 17, the relevant portion, presently relevant portion follows. An applicant for leave to appeal must convince the court on proper grounds there is a reasonable prospect or realistic chance of success on appeal. A mere possibility of success, an arguable case, or one that is not hopeless is not enough. There must be a sound, rational basis to conclude that there is a reasonable prospect of success on appeal. And that, with respect, we submit is the lodestar for today's hearing. Now, what is significant in this regard, we would add, and it is an additional factor in this particular case, is the following. We've read Mr. Zuma's application, we've read his written submissions, and we have also heard his counsel today. And what is clear is that his main grounds of appeal do not concern trial-related prejudice caused by the fact of delay. In other words, he doesn't rely on the death or disappearance of witnesses, the fading of memories, the loss of documents, or the like. His case is a different one. They relate to prejudice he claims to have suffered due to the past actions of past NDPPs, especially Mr. Nuka and Mr. Pikoli, and of the former head of the Directorate of Special Operations, the DSO, Mr. McCarthy. And the reason why that's important is that, as the court knows from its survey of the law governing applications for a permanent stay of prosecution, and as the Constitutional Court said in paragraph 27 of the case Wild versus Hoffert, 1998, 3 SA 695 Constitutional Court, if the prejudice alleged by an accused is not trial-related prejudice, the circumstances of the case must be so extraordinary as to make the otherwise inappropriate remedy of a permanent stay of prosecution nevertheless appropriate. And that is the legal requirement for success in a case such as this one, which is not one about trial-related prejudice caused by delay. And so, when one marries the test for reasonable prospects of success to the requirement for success in the main case on the grounds which are advanced before you today, When assessing, in other words, whether Mr. Zuma's grounds of appeal are plausible, to use that as a generic, what must be determined is whether there is a sound, rational basis to conclude, on the evidence, that he has a realistic chance of meeting the very high standard for an application for a stay of prosecution based on prejudice that isn't trial related. And for the reasons which we shall give in a moment, we respectfully submit that none of Mr. Zuma's grounds of appeal comes close to meeting this high standard. But before addressing the merits of those grounds, we wish to point out that, as the court will have noticed from the written and oral argument, that a large part of his counsel's submissions comprise with respect is general argument. And we refer particularly here to the extensive sections in the heads arguing that the court didn't properly consider the alleged violations by the NPA of Mr. Zuma's constitutional rights to human dignity, equality and freedom, and to a fair trial, and arguing that the court didn't properly consider the constitutional issues such as his fair trial right in this application, or the NPA's constitutional and statutory obligations to act independently, impartially, and without fear, favour or prejudice. And all we wish to say about those very extensive sections of the argument addressed to this court is, with respect, this court did consider in detail the constitutional issues, including those rights, and we refer to paragraphs 113 to 125 of the judgment. And as regards the constitutional and statutory obligations of the NPA to act independently, etc., the answer is the same. We refer to the judgment at paragraphs 142, 164, and 165 in particular. So, in what follows then, we shall focus on the main factual allegations, the underpinnings of these generalized conclusory submissions of constitutional violations and unlawfulness and the like. And if I may then, we are going to start first with Mr. Zuma's August 2003 decision not to prosecute Mr. Zuma together with Mr. Sheikh. Now, as far as that is concerned, the first point we wish to make is that the court dealt extensively in its judgment at paragraphs 126 to 132 with Mr. Zuma's allegations on this score. And we respectfully submit that on the evidence in the papers, there is no prospect of an appeal court overturning this court's findings, and especially its conclusions in the judgment at paragraphs 131 and 132. Firstly, that Mr. Nguka applied a legitimate test when deciding not to prosecute Mr. Zuma, and secondly, that Mr. Nguka's evidence that he felt obliged to explain to the public why he decided not to prosecute Mr. Zuma, despite the prima facie case disclosed by the indictment, namely to avoid an inference that Mr. Zuma was receiving special treatment, that was uncontested, as this court with respect rightly found, and we submit a compelling reason. So we submit Mr. Zuma's contention that this court should have found that by explaining to the public why he decided not to prosecute Mr. Zuma, that Mr. Nguka was playing a political role or abusing his prosecutorial powers to advance or promote a political outcome, is baseless. It's underpinned by no facts whatsoever. It's a theory. In fact, with respect, it's a conspiracy theory. It's comprehensively disputed by Mr. Nguka in his affidavit, as also by Mr. Dana in his affidavit. This is an application in which final relief was sought on motion. What they said is not inherently implausible, far-fetched, or falls to be rejected on the papers. It was open to Mr. Nguka to apply for the referral of these or other issues to oral evidence. He did not make any such application. The court is consequently obliged, as it did by the Plascon-Evans rule, to have regard to the content of those affidavits and the allegations made by the applicants which were admitted by the NDPP, and to adjudicate the case on that basis. With the greatest respect to my learned friend's attorney, there is absolutely no merit in the contention that this court adopted a sanitized version of the facts. It applied the Plascon Everence principle correctly in a very detailed judgment setting out the facts spanning these many years. We heard today again about a dry run. There is no prospect of an appeal court upholding Mr. Zuma's unsubstantiated allegation that the NPA's decision to prosecute Mr. Sheikh was a dry run for the prosecution of Mr. Zuma. The reason is it's not underpinned by any facts. But
Mr. Beckenbach, I understood Mr. Sikakane to say, well, I'm simply putting to you what was submitted to us.
yes,
Regarding the fact that the trial court would be influenced by the decision of the SCA.
that
I
is,
understood your heads to mean that the old rule in Arlington versus Newthorne still applies, and accordingly no court in its decision-making can rely simply on what was said by the other court, unless the principle or the ratio is used.
so there are three principles which interlock, and the argument is tended to allied the three. The first is that the findings of higher courts on questions of law, generally applicable questions of law, are binding on lower courts. And that applies particularly to the contention that it is unfair to prosecute two alleged co-actors separately. That matter was dealt with in general terms by the Constitutional Court in the final Sheikh appeal, and in paragraphs 47 to 50, as this court noted in its judgment in paragraph 133, that proposition was rejected. In other words, there is no principle of our law which requires that co-accused be prosecuted together. So that's the first class, legal principles which are laid down. And yes, Mr. Zuma is right that in the course of that litigation, that's the Sheikh litigation or the Sheikh criminal litigation, certain legal principles were laid down. That must be distinguished and completely from a related contention which took its most extreme form in a complaint in the notice of application for leave to appeal, that given this court's judgment, all that now needs to happen is for the trial court to read the record of the Sheikh proceedings and to proceed to sentencing. That totally misunderstands the nature of our criminal justice system. The state has presented Mr. Zuma with an indictment. He will be called to plead to the charges in that indictment. And if he pleads not guilty, the state must adduce evidence in support of the allegations it has made against him. He will have an opportunity to object to the admissibility of the evidence, to test its strength through cross-examination, obviously to adduce evidence of his own. Only evidence properly admitted in his trial may be and will be considered.
Well, isn't Mr. Sikane's submission, as I understand it, is that the lower court, for instance, might be constrained to reject, let's just make an example, the encrypted facts, might be constrained not to accept it as admissible because it has already been accepted as such by the SCA.
Undoubtedly, if an objection is raised to the admissibility of the encrypted facts, and we don't know whether or not such an objection will be raised, but if it is, it will have to be adjudicated on its merits. We know that such an objection was raised in the Sheikh trial. The facts was admitted, as I recall, as an executive statement made by one of the co-accused in the course of the Ray's Gesta. As I recall correctly, in the Supreme Court of Appeal, a further reason for admitting it was propounded, and that was under an exception under the Law of Evidence Amendment Act to the hearsay rule. Undoubtedly, those specific findings which go to the legal bases upon which a document like this could be admitted will be much debated and will have to be decided. But ultimately, the court will have to decide with reference to the facts then prevailing. For instance, whether to allow, in the interests of justice, the admission of the facts if it is being tendered on a hearsay basis. And the trial court will have to decide for itself. And if the matter goes on appeal to a higher court, that court will have to decide for itself in the circumstances then prevailing. We know, for instance, and the court knows, that the person who physically typed and sent the facts, Ms. Delique, has died. That may give rise to different considerations under the Law of Evidence Amendment Act to those which prevailed at the time. But the point is, the state will nevertheless have to adduce whatever evidence it wants to. Whoever is acting for Mr. Zuma or is co-accused will have the fullest opportunity to object to their admissibility, and the court will have to rule on that. As far as the most extreme proposition is the one about reading the record and proceeding to sentencing. That is Her Ladyship Justice Steyn has just put to me. It flies in the face of authority in the Old English case of Hollington and Hewthorne. In Mulawudzi's case, at paragraph 40 and paragraph 108, there are references to two earlier decisions, one in the SCA and one in the Constitutional Court, in which Hollington and Hewthorne has been affirmed. The conclusions, the findings of fact which the Chake trial court made, and obviously the ultimate conclusion as to guilt or innocence of the various charges, those are the opinions of other courts, just as the conclusions of the public protector on which it is sought to rely, that's the opinion of someone else on a matter which arises for decision. They are not admissible, they are not relevant, and they can safely be left out of account. What this whole line, with respect, presumes is that, and I say this with the greatest respect, is that the people presiding over Mr. Zuma's criminal trial will not understand the basics of the conduct of a criminal trial. Because what I'm been submitting to the court is well known to it from its experience. This is not rocket science. The state makes an allegation, it must prove it through admissible evidence. You cannot rely on a finding in another case involving other people, even if that person happened to be your alleged co-actor in the offence in question. If the state makes the election, as it did in this case in 2003, not to prosecute Mr. Zuma together with Mr. Sheikh, it must live with the consequence of that. What is that consequence? It will have to leave all of the evidence again. As far as the dry run itself is concerned, all we wish to say about that was this in proper motive. Gather evidence for the second case against Mr. Zuma, and ensure that he's prejudiced through the leading of evidence concerning his dealings with Mr. Sheikh, or Mr. Sheikh's dealing with him and with the French company. Mr. Nguka dealt with that in his affidavit at some length. We have given the references in our heads of argument, and he's explained ultimately it boiled down to one thing and one thing only. He put together this team, and together they looked at what Mr. Downer and the other prosecutors wanted to do, and they came to the conclusion that the NPA didn't have a winnable case against Mr. Zuma. He set out his reasons in a contemporaneous report to the Minister of Justice, and this court has recounted those reasons in its judgment. I'll move on then to Mr. Zuma's contentions concerning Mr. Pikoli's 2005 decision to prosecute Mr. Zuma.
Yes, I think it's 1 o'clock. Can we come back at 2:15? 2 o'clock. 2 o'clock.
Keep you on that road to my king, not saying at night. I've had to do it a couple of times. I don't like it.
Oh, God.